Recording. There we go. This is the April 24th, 2025 hearing for Z0054-24, remanded decision from Luba regarding Huffman K9. My name is Joe Turner. I'm the county's hearings officer. I'll start with some brief announcements and a summary of the process that will follow so everyone understands how you can participate in the hearing. I start by saying I'm not a county employee. I'm licensed as an attorney and trained as a planner. I serve under contract to the Board of Commissioners. I say that so you know you're getting a somewhat independent review of the application before me today. My role as the hearings officer is to conduct public hearings and make decisions about certain land use matters in Clackamas County. In making those decisions, I'm required to apply the county's existing laws. I don't have the authority to vary from or change the laws. If you think that the laws need to be changed, you can work with Planning Commission and Board of Commissioners to do that. But state law requires that this application be judged based on the laws in effect when the application was filed. As a hearings officer, I'm to provide an unbiased decision maker. I believe I am unbiased with regard to this application. I have not had any pre-hearing contact with any of the parties regarding the substance of the application, and I don't have any interest in the subject property or any of the surrounding properties. But anyone has the right to challenge my impartiality, to argue that I'm biased in one way or another, and you can do that when it's your opportunity to testify. Procedure will follow. I'll start by asking staff to summarize where we're at, I guess, with the LUBA remand, and then the applicant will have the opportunity to present their remand request, application on remand, I guess you would call it. Then I will give the appellant, the appellant at LUBA, the opportunity to respond to the testimony, and then anybody else who wants to testify about this application in support, in opposition, or with questions or concerns. Once everyone's had an initial opportunity to testify, I will give staff and the applicant alone the opportunity to respond to the testimony that was offered. If those responses include any new evidence, I will give everybody a chance to respond to the new evidence. Otherwise, I will close the public portion of the hearing without taking further testimony from the public, including the LUBA appellant. Generally, I will issue a written decision within about 2 weeks after the close of the record. I will send my decision to the county. The county will send it to parties of record. So anybody who testifies orally or in writing before the close of the record will be sure and receive a copy of my decision when it's issued. Anyone with an interest in this application may offer relevant oral or written testimony. However, testimony should be relevant to the applicable approval criteria. And in this case, those are limited to the issue of whether the application complies with Section 40105A1 of the county's Zoning and Development Ordinance and Oregon Revised Statute 215-296-1 regarding whether the proposed use will not force a significant change in accepted farm or forest practices on surrounding lands devoted to farm or forest use, and will not significantly increase the cost of accepted farm or forest practices on surrounding lands devoted to farm or forest uses. Because this is a remand application, it is limited to that single issue. All other issues are not relevant to this remanded proceeding. Also, please don't repeat testimony offered by yourself or earlier witnesses. And it's important that all parties make their best case to me. My decisions are final for purposes of the county, but this decision may be appealed to LUBA, again, the Land Use Board of Appeals. However, LUBA generally will not allow new testimony and evidence on appeal. They'll decide any appeal based on the record before me. So if you feel it's important that myself or any future decision maker knows something about this application, and that one relevant issue, you must need to make sure that gets into the record before me. As noted in my decision, I will hold the record open after this hearing for 3 weeks. My remand procedure order. 1 week for anybody to submit new evidence and testimony, 1 week for everybody to respond to whatever was submitted during the first week, and a final week for the applicant alone to submit a final written argument without any new evidence. When you testify, please beginning by stating your name and full mailing address. Please spell your last name. So some names appear on my screen, others are pseudonyms. And if you represent someone else, please say so. But that concludes my introduction. Ms. Lord's going to explain how the online process works and we'll proceed from there.
Thank you. This public hearing will be conducted virtually using the Zoom platform. Panelists for today's hearing, which include the hearings officer, county staff, and the applicant, have both audio and video capability. Audience members who have joined the meeting will have their microphones muted unless they wish to testify, in which case they will be called upon to do so by the county staff moderator. Audience members' video will not be turned on at any time. Today's hearing is being recorded as required by law. The county will make every effort to post the recording on the county's website later today. There is a designated time during the hearing when it will be open for testimony. The hearings officer will make this clear when it is. If you want to provide testimony, you'll use the raise hand feature. For attendees on your PC or iPad, you have a raise hand button on your Zoom bar at the top or bottom of your screen, depending on your device. When the moderator switches you over to provide testimony, your screen will look different for a little while. Primarily, you will see all participants' cameras, not just the one who's speaking. Staff will call upon you when it's time for you to provide your testimony. Be sure to state your name and mailing address when you begin. Once you've provided your testimony, your microphone will be muted and your screen will be returned to normal. If the record is left open at the end of this hearing and you wish to submit additional written testimony, you can email that written testimony to myself at mlord@clackamas.us, MLORD@clackamas.us, or you could mail it to the Clackamas County Planning and Zoning Division at 150 Beaver Creek Road, Oregon City, 97045. My contact email address is also available on the webpage where you found the link for today's hearing. Testimony must be received by 4 p.m. on the day the record closes. People who testify and provide their mailing address will receive a copy of the hearings officer's written decision. If you do not wish to testify but would like to receive a copy of that decision, you must provide your email or standard mailing address to me by emailing me at mlord@clackamas.us or by entering it into the Zoom chat function during the hearing. And I do have a short PowerPoint presentation to share with you. So I will go ahead and share my screen. Okay, today, as Mr. Turner already mentioned, we are meeting for the remand hearing of land use application Z0054-24. Which was reviewed concurrently with land use application Z0055-24, which is a conditional use permit, and it was a non-conforming use permit for a property on Pelican Court. And here's just an aerial photo map showing generally the location of the property. The property is in the exclusive farm use zoning district, or EFU, and it is about 5.25 acres in size. The initial proposal that was reviewed originally was to establish a commercial dog boarding kennel within 2 buildings on the property. 8 dogs would be in an existing structure and 8 dogs would be in a new or proposed structure. The property owner would also continue to operate dog training, which is an allowed use in the EFU zoning district and was not part of the discussion associated with the conditional use permit. We considered, originally we considered this site plan for the proposal, with the blue circle in the northeast corner of the property is a 650 or so square foot building, which is the proposed building that would house 8 dogs. And then in the red circle was the location, or is the location of the existing structure that is proposed to house 8 other dogs associated with the kennel business. The history of this particular land use application and where we're at now, as Mr. Turner mentioned, we originally reviewed this conditional use permit and non-conforming use permit back in July. It was conditionally approved by the county. Following that approval, it was appealed to the Oregon Land Use Board of Appeals. Upon review from LUBA, the LUBA remanded that back to the county, and that was their decision was issued in December of 2024. And so that brings us to today's remand hearing. As Mr. Turner mentioned, we are specifically looking at one particular criteria, an associated zoning and development ordinance criteria that mirrors an Oregon revised statutes criteria particular to this conditional use application. Specifically, the LUBA decision wrote, and I quote, "On remand, the county must identify the surrounding lands, the farms on those lands, the accepted farm practices on each farm, and the impacts of the proposed non-farm use on each farm practice." And so, as we already mentioned earlier in the introduction to this hearing, that specific criteria that's being referenced is this one here that I've got on our screen. So a use may be approved only where that use will not force a significant change in accepted farm or forest practices on surrounding lands devoted to farm or forest use, and significantly increase the cost of accepted farm or forest practices on those surrounding lands devoted to farm or forest use. So effectively, this is what we call the impacts test. The applicant, in response to this remand, did provide a packet of new information with new evidence to support their argument and how that this particular criteria is being addressed. That has been entered into the county's record as exhibit number 44. There were a number of associated files with that, and so we've labeled those exhibit 44 and A through L. And those are all uploaded onto the county's website for consideration. Generally, those exhibits include a series of analyses and reports and information pertaining to how this proposal does in fact meet that zoning and ORS criteria. There's analysis of surrounding farms, pointing out what the farming use is on surrounding properties. There's different reports or meetings with ODA, the Oregon Department of Agriculture, and information on their confined animal feeding operation facility and an inspection that was done on the property. There's a animal waste management plan that, coupled with a drainage map and stormwater drainage videos, is submitted to demonstrate that the waste management plan is in fact suitable for the site, and that it wouldn't have a significant impact on runoff or contamination to a neighboring hazelnut farm. The applicants also address general concerns from neighbors that the impacts of this dog kennel really relate to the impacts of dogs being on the property. I think the argument there is that dogs have been on the property with the dog training business for at least 5 years, and there has not been an identified increased cost in farm practices from the dogs being there, and so the kennel should be similar in that type of impact. Lastly, they provided a map of dogs and surrounding properties. There's some concern that the dogs would have a negative impact on livestock and cause livestock anxiety, but the map demonstrates that there are in fact already dogs in the surrounding area on surrounding properties. And again, relating back to how that would not significantly increase the cost of accepted farm or forest practices on surrounding lands. So that's my quick overview and summary of where we're at and what we're considering today. And I'll stop sharing my screen.
Okay, where are we with the remand clock? When does that expire? When do I have to get this decision?
Yep, great question. Let me take a look and I will get that for you.
Okay. While you're looking, I'll go ahead and go to Connor, the applicant's attorney.
Mr. Turner, for the record, my name is Mike Connors. I'm an attorney at Hathaway Larson LLP. Address is 1125 Northwest Cooch Street, Suite 550, Portland, Oregon 97209. I represent the applicants in this matter, which include Huffman K9 Obedience, Jensen Huffman, and Welkin Engineering. And as you know, and staff indicated, we submitted a April 17th packet that addresses LUBA's remand and our position and arguments with respect to the remand issues. And for purposes of the hearing today, I'm going to summarize those points. And then after I'm done, Mr. Huffman is going to ask for just an opportunity to make some brief comments to you, but I'm going to handle most of the majority of the issues. And if you have any questions as I go, please feel free to ask questions. So I'll start with LUBA's decision since that defines the scope of the remand. And the Guays brought multiple assignments of error, all of which LUBA rejected except for the one issue that's before you. And on that one remand issue, LUBA concluded that the findings for ZDO 401-05A1 and ORS 215-2961 were inadequate because they did not adequately identify, one, the surrounding lands with farm uses, two, the farm practices or uses on those properties, and three, the impacts of the proposed kennels on those farm uses. And LUBA's remand was specific to the findings. There was no evaluation of the evidence or conclusion that there was inadequate evidence to support a potential finding of compliance, merely just that the findings were not specific enough to the criteria laid out in those two sections. And although LUBA's remand is limited to that specific issue, there are other portions of LUBA's decision resolution of other appeal issues that are informative. The first one is that LUBA rejected the Guays' claim that your decision failed to adequately address ZDO 1203.03D, which includes very similar criteria to the criteria that are before you on remand. That particular section requires a finding that the proposal will not alter the character of the surrounding area in a manner that substantially limits, impairs, or precludes the use of surrounding properties for the primary uses allowed in the zoning district. Since farm uses are one of the primary uses and it's got similar language, I think basically what LUBA did is they looked at that section of your decision and said, we agree that these findings are adequate and that there is substantial evidence to support them. I think they just distinguished it from the particular, the 40105, because those findings weren't as specific to the impact issues. LUBA also concluded that the Guays failed to adequately raise an argument regarding the adequacy of stormwater containment. And so based on that, that's not an issue that's before you, although I know that that was one of the components that the Guays had. And lastly, LUBA specifically concluded that based on the evidence in the record, including the wastewater management plan that we submitted, that there was substantial evidence, and it was appropriate for you to rely on that to demonstrate that there were no significant impacts under the 1203-03D criteria. So next, I want to address the particular criteria that are before you on remand, 401-05A1 and ORS 215-2961, which are commonly referred to as the significant impacts test. And basically, that test requires that certain quote-unquote non-farm uses are allowed only if they will not force a significant change or significantly increase the cost of accepted farm practices on surrounding farmlands. The Stop the Dump Coalition case that we included in our April 17 letter is really sort of the key case that defines what does that standard mean. And basically what the court said is an applicant has to demonstrate that there'll be neither a significant impact or change on farm practices or a significant increase in the cost of those farm practices due to the proposal. The court emphasized that the impact must be significant. It's not just any impact, it's a significant impact that causes one of those changes or increase in costs. And then the court also noted that even if there's insufficient evidence to demonstrate compliance with the criteria, the county must consider if there are conditions of approval, clear and objective conditions of approval that could be imposed to ensure compliance. That's basically a summary of what the Stop the Dump Coalition case says, which I guess I would suggest that you use sort of as your roadmap for purposes of this remand issue. So the first criteria, or actually the first two criteria under the test, are identifying the farmlands and the farm practices on those lands. And we provided you a farm map and narrative that basically identifies all the surrounding properties that have farm uses on them, and information about that, the nature of the farm use, as well as the property owner and the location. And generally what you'll see from that is the surrounding farms, which are relatively small, consist of a variety of different farm uses that include hazelnut farm, hay or grass seed farm, Christmas or commercial tree farms, apple tree farm, and then farms with horses, cattle, and mules. And you'll see that on the map sort of spread out among the various areas. And this is the information that we recommend you use to adopt findings on those first two criteria about these are the surrounding farmlands and these are the nature of the farm uses on those. So next I'll go to addressing the specific significant impact test, which we again addressed in our April 17 letter, where we laid out our case as to why we believe that we can comply with that criteria. And honestly, we feel that the existing record that was before you in the original proceeding was sufficient for you to be able to make that determination. But we agreed to reopen the record because my clients were agreeing to additional concessions to try to be responsive to some of the neighbors' concerns. We also wanted to submit some additional evidence just to make sure that it's absolutely clear this go around why it is that we believe that the kennels will not create any of these significant impacts on surrounding farm uses. And so I'll go through those quickly to kind of address key issues, arguments, and evidence on the impacts. And really what we've done is use the prior record where there was a number of different neighbors that testified and identified specific alleged impacts. And we addressed those impacts in our April 17 letter, and I'll go through these now. But the first one I do want to note before I get into addressing those specific impacts is what we consider perhaps the strongest evidence that we have to demonstrate that the kennels will not create any significant impacts. And that's the fact that Huffman Canine has been operating a permitted dog training facility on the property for over 5 years without causing any of the significant changes in farm practices or significant cost. You had the original record. You didn't hear any evidence during that proceeding about anything that with the existing dog training facility that has created significant changes or significant increases in cost. And really the kennels are directly associated with that dog training facility. The purpose for the kennels is really to support the dog training facility by enabling my client to be able to board dogs that are in the training program overnight, especially if they're in multi-day training sessions, versus what is currently happening right now where owners have to drop off their dogs every day, pick them up at night, and that creates both burdens on the dog owners as well as some impacts on the neighbors that the kennels are designed to try and mitigate or reduce. And if you look at most of the concerns that have been raised by the neighbors, they're really not specific to the kennels. They're more specific to the presence of dogs on the property. And again, that's why we believe the fact that there have been dogs on the property in the dog training facility, which will be part of sort of the kennel operation, and none of those significant impacts. We think that's perhaps the strongest evidence to demonstrate that the addition of the kennels will not create those significant impacts. Next, I'll go to sort of the list that some of the neighbors had raised in the original proceeding and provide comments because some of it is just to let you know kind of what our position is, and some of it relates to the new evidence that we've submitted on remand to address these issues. And the first one is what it seems to me is the Guays, the appellants in the Luba appeal, Perhaps their biggest concern is that, and that is concern that dog waste or wastewater will contaminate their hazelnut farm. And there's several reasons why we believe that is not the case and there won't be that type of an impact. First one relates to the first point I brought up, which is there have been dogs on the property for over 5 years. They're obviously creating waste on the property, and there have been no impacts to the hazelnut farm, no contamination based on the nature of what the GWA said. If there's any contamination, it would completely shut their farm operation down. I think you can logically conclude that there has been no such impact over the last 5 years, notwithstanding the presence of the dogs associated with the dog training facility. Second reason is we submitted a wastewater plan. And if you look at Luba's case, the decision, Luba specifically determined it was reasonable and appropriate for you to rely on our wastewater plan, and at least finding that there won't be any impacts under that other criteria, 120303D. We think you can rely on it to address this criteria as well. And some of the new evidence relates to a confined animal feeding operation permit, or CAFO permit, that's issued by the Oregon Department of Agricultural, ODA. In the original proceeding and in some private negotiations we had with the GWAs were really wanted my clients to pursue a CAFO permit or whatever permit from ODA to deal with the waste issue. And when we originally looked into it, ODA, the CAFO permits, the threshold is only for operations that generate 100 gallons of wastewater per day. And our operation, I think, was approximately about 4 gallons per day. It was well below that. But in light of the Luba appeal and the remand, my clients reached out to ODA, had a couple site visits, and really kind of pushed them to say, we understand that a permit's not required, but we have a neighbor that's concerned about this. We want to try to be responsive and alleviate those concerns, and we're asking you if you would be willing to process that permit. My clients met on site multiple times with ODA representative, and they basically agreed that, notwithstanding the fact that it's not required, that they will agree to process and issue a permit in this case. We submitted that evidence from the 2 inspections, on-site inspections that they had, as well as a draft waste plan. And I will emphasize draft because that's still in process, waiting for feedback with ODA. And then an email from an ODA representative that confirmed that he had been having meetings and is working with my clients on that CAFO permit. Basically, that evidence also shows, and ODA representative advised us that ODA agrees that the plan, wastewater plan that we have in place meets their requirements. They support it with one exception. And the one exception is that ODA is recommending that whatever wastewater that is generated from the mopping activity in the kennels, that as opposed to be putting down the storm drainage in the driveway, that it be put into a grassy area, which is a typical discharge area that ODA requires as part of these CAFO permits, which my client has agreed to. So to wrap it up, ODA, they can't process or issue the permit until you conclude this decision and hopefully approve the project. And if so, we can use that to get a land use compatibility statement, and then ODA will process the application. And my client is willing to agree to a condition of approval that requires that CAFO permit, assuming that ODA continues to state that they will issue it, notwithstanding us being below the threshold for wastewater. And we're hoping that that will alleviate a lot of the GWA's concerns, since that was the type of permit that they were really pushing for. It provides some objective kind of checks and balances, requires yearly inspections, and ODA is the one that will review the plan and ensure that our wastewater plan satisfies their standards. So we think that that's a big new piece of evidence that really does demonstrate that we're not going to create any impacts with the wastewater. There were other evidence that we submitted on the wastewater related issue. One is a topographical and drainage map. The GWA's had expressed some concern about drainage coming onto their property, and what these maps show is that the property drains to the southwest away from the GWA's property. And so therefore, to the extent there were to be any runoff, it's going in the opposite direction. And we also introduced 2 videos The videos kind of show two things. One is the area right around the kennels, to show that during a very rainy activity, a day where there was steady rain, you can see rain on the ground, that in the specific area of the kennel, it's dry, because there's 3 large redwood trees there that really do soak up any moisture in that area. So it keeps that area much drier than other portions of the property. And that's the area right adjacent to the Guay's property. And then secondly, there's another video that just kind of shows how the drainage happens on the property in real time. It's a pretty heavy rain event that video was taken, so you can kind of see where the direction of the water, again, to the southwest away from the Guay's property. And then the last thing on the wastewater issue, and this is something that you heard before, but I just kind of want to emphasize, and that is that while we understand the Guays have concerns about potential waste from the kennels leaching onto their property, there are already sources of animal waste on their property. We believe the Guays have a dog. They have chickens. You've heard testimony. We provide additional testimony. There are other dogs in the neighborhood, some of whom roam free in the neighborhood, could easily go on their property. There are wild animals in the area, coyotes, raccoons, geese. They have access to the property, all of which waste could be directly in the Hazelnut Farm property itself. So while we respect the fact that the Guays have concerns, and they do, seem to honestly have concerns about that, we're not quite sure why that is something that is such a concern given the direct source of waste that can occur on their property, because their property is not enclosed. And so dogs and other wildlife and their own pets create waste on the property. Next issue I'll address is traffic, since some of the neighbors raised that. And as you previously concluded in your original decision, the kennels will actually decrease, not increase, the traffic on the road, because it will allow the dogs in the training program to stay overnight, avoid owners having to come pick them up, drop them off, pick them up every day. So therefore, it actually will mitigate traffic impacts. Also introduce some new information to demonstrate my clients are continuing to contribute towards the maintenance of that road. We provided those texts in Exhibit 44K that show that that's still ongoing. And then lastly, I'll just say from a legal standpoint, even if the alleged traffic impacts are accurate, I'm not sure that that is a impact related to a farm use. Maybe an annoyance that some people have, but it's not a farm-related use impact. Next issue I'll address is noise. We do want to note that there was a separate assignment of error at LUBA regarding noise, and LUBA rejected that. But because neighbors raised noise impacts as potential impacts on their property, we wanted to address that and recommend that you adopt findings to that extent. And then basically the concern is barking dogs will create noise impacts. And as you previously determined in your original decision, many agricultural activities generate noise, or noise from barking dogs is pretty consistent with other rural noises. Barking dogs are common in rural areas, or common in this specific area, as we showed on the dog owner map, that we've got multiple surrounding properties with dogs. And to the extent that there are any noise impacts from barking dogs, again, we have the existing dog training facility, so that would indicate that there would be some sort of an issue there, but it's an existing issue. It's not a new impact that the kennel is introducing. But with that being said, my clients still have tried to impose measures to be sensitive to the neighbors' concerns and to mitigate any impacts from barking dogs. It includes, first of all, operational measures, which have been in place with the dog training facility, and that is that dogs are not allowed to bark. If they do bark, they're immediately corrected by their owner or trainer. We have barking collars that we can use to prevent dogs, if they don't obey that command, to not bark. And then there have been several noise mitigation measures that my clients have proposed. The kennel will be in an enclosed building. And one of the new things that improvement that my client has made is my client has now fully enclosed the outdoor run area with a fence. And we provided pictures to that effect in Exhibit 44J that show that they're, so now it'll be completely fenced in, which will provide a little bit more of a buffer. My clients already agreed to insulate the building to limit sound transmission. They've already agreed that the kennel open areas will be closed from 8 p.m. to 8:30 a.m. to avoid any kind of barking at night. And then, as I indicated earlier, we have bark collars that can be used in the kennel itself. The other evidence that my client previously provided was a expert noise study that demonstrated that noise from any barking dogs would not exceed the county noise standards, would comply with those standards. And then again, I'm not sure, even if the allegations of barking dogs were true, I'm not sure that that's specific to an impact on a farm use or how that would impact or change that farm use itself. Fencing was an issue that was raised in the original proceeding, but it's important to note that although the fencing impact was concern about dogs going on to other neighbors' properties, the only evidence of that occurring from a dog from my client's property is actually my client's livestock dog. The livestock dog's part of their farm use because my clients are farmers. They have goats. They have farm uses on their property. And there was an instance where that dog crossed over into the property owner to the north. That's not relevant because that's their farm dog. It's not part of the training facility or the kennels. But nonetheless, my clients did agree to put up some new fencing along that border with that north property owner to kind of address that prior incident. And we provided pictures of that as well. The next impact that was raised by some of the neighbors was livestock anxiety, the presence of dogs creating anxiety. And again, as you indicated, dogs are common in rural areas. There are dogs in this area. There's already a dog training facility. So to the extent the presence of dogs were in fact to create anxiety in livestock, that's something that's already present, and there's no indication of any impact from that current dogs being present in the area. The last issue, impact issue that was raised was property values, concerns about impacts on property values. We cited some case law that from LUBA that stands for the proposition that, as you may have heard in other indications, their impacts on property values are often cited in many cases. And LUBA has determined that unless the approval criteria specifically references property impact values, that's not relevant. And that's not the case here. It's not even really tied to a farm use itself. But because of that, we don't think that that's a basis for finding it. And then lastly, LUBA has been very clear that to the extent there are allegations of impacts on property values, there needs to be evidence. Actual evidence. It can't just be mere claims of impacts. And here, there's no evidence in the record of an actual decrease in property values as a result of the kennel. So with that concludes our kind of list of going through the various impacts. And I'll just kind of give some conclusory comments, and then I'll turn it over to Mr. Huffman to address. Just to emphasize, LUBA's remand, very narrow. It's only limited to those specific criteria, the county criteria and related statute, and it only relates to the adequacy of the findings, not the evidence. And so on remand, really all you need to do is adopt specific findings following addressing those three criteria that LUBA laid out. And as I indicated earlier, we felt that the evidence was more than sufficient to support a finding of compliance with that criteria, but both to bolster our case and to be sensitive to some of the neighbor concerns that we heard, my clients have made additional improvements, offered up additional concessions, introduced additional evidence to try to make it clear that they're trying to be responsive to those. And based on the record that you have before you, both the original record and new evidence, we believe that there's overwhelming evidence that would support a finding that the kennels will not force a significant change in farm practices or significantly increase the cost of the farm practices. And therefore, we ask that you approve the application on remand and adopt new findings consistent with LUBA's order. That concludes my comments, unless you have any questions. And if not, I will turn it over to Mr. Huffman to give just some brief comments from him.
Okay, I just have, excuse me, one question. The applicants identified the farm uses in the area with your map and your summary, and you talked about the potential impacts of this use on those and argued that there won't be any impacts. But I didn't see anything about farm procedures associated with horse boarding, I assume, is going to generate traffic in and out, and have horses there. Christmas trees, they're going to be harvesting, and the hazelnuts, the contamination. Well, it's not, sorry, the hazelnuts, I don't know how they harvest them. It's my understanding it's a vacuum or something, but there's nothing about the procedures, how those farm operations, what they do on those farms. And I wonder if you can address that.
Yeah, so if you feel the need for us to provide additional information on those farms, we can
I
certainly
think
do
that's
that.
what that
Yeah.
was the second criteria that Luba said, that have information about farm practices, and that appears to be missing.
Yeah, no, I guess the way that we looked at it was that by identifying the nature of the farm uses and looking at the nature of the proposed use and potential impacts, there's really no correlation. In other words, I guess to answer your question, I don't think any of the potential practices or specific farming activities that could take place on those farms would be impacted by the presence of the kennels. And I don't believe that the criteria under the significant impact standard requires that you get into the specifics of each farm practice on each property. I think what that criteria is saying is once you identify the nature of the farm, the farm properties and the nature of the farm uses on those properties, are there any specific procedures or practices on those farms that would conflict with the proposed use? And basically what we're saying is when you look at the nature of the use, hazelnut farming, apple tree, the Christmas tree farming, there's nothing inherent about those specific farm uses that would create any kind of conflict or impact that the kennels would create. So that's basically, I think, the response to my general response to your question, but we can get some additional specifics on the specific practices to see if there's anything particular in those kind of farm uses that are unique or unusual, or whether there's just kind of general type of farm practices that you would see for those kinds of farm uses.
Okay. Luba specifically mentioned practices, so if that's there, I think that makes it easier to resolve address the issues that Luba has remanded on.
Understood.
Okay, thank you. Mr. Hoffman, I understand you want to testify.
Well, I appreciate the opportunity to testify and appreciate everybody's presence here today and attention to the matters. Both Mike and Melissa did an outstanding job really kind of capturing all of the different issues around this. So I'm not going to drag on very long, but I just think from a personal note on behalf of both my wife and I and our business, our intention has never been to impact our surrounding community. We feel like every single change that we've made has taken into consideration our neighbors and what they do on their properties and their general enjoyment of their home and their life with their livestock, their life with their farming, their life with their own dogs. I feel very strongly that as we go through day-to-day operations, we are not impacting our surrounding neighbors. And when there is any sort of dispute that we've ever had, and neighbors have disputes, we've talked that through, addressed them, and outside of this dispute with the Guays, we've been able to come to a resolution in every single case. So, we're just really committed to seeing this to a successful completion where we can operate a responsible, permitted, and compliant kennel that works in a cohesive way with our neighbors and surrounding lands. So anyway, I just wanted to say thank you, and I appreciate your time.
Thank you, Mr. Hoffman. Mr. Connors, just to make sure, is anything further from the applicant?
Not at this time, Mr. Turner.
Okay,
Thank you.
didn't want to skip over.
Appreciate that.
Mr. and Mrs. Guays, I assume you're Vicky's iPad on my screen. You'll need to unmute yourself. You are still muted. We're not hearing you. There we go.
How about that?
Where's the printout? Will do that.
Now we're hearing you.
I need it.
Okay. Hi.
Hello, Mr. Turner. My name
Hi.
is hi.
Kevin Guay, and my wife is just getting a piece of paper. Her name is Vicky Guay. We live at 7654 South Mark Road, Canby, Oregon, and we own the property, and we're the, as you're aware, the appellants here. I'll just start this way, and hopefully this makes sense to you. Mr. Turner, good afternoon, and everyone in attendance. And Mr. Turner, thank you for conducting the hearing and allowing us the opportunity to voice our concerns regarding the proposed non-conforming dog facility that borders our property and is operated by the Huffmans. We firmly believe the evidence, and we're going to submit a lot of evidence today because it was clear to me in the presentation, and this is not their fault, they don't have the practical experience, and you alluded to that. What are the practices? Well, the reason why I don't have my attorney here present, because if this does have to go to appeal, we're ready for it, and I've got the money, but we hope that doesn't have to happen. But the point is, my job here today is to help you really understand our practices so you can make an informed decision. And,
Okay.
and I'm not here to persuade you. I'm just going to give you the evidence. That's your job, not mine. Anyway, we firmly believe the evidence that we're going to submit and present today will allow you and a reasonable person to conclude the dog kennel facility has and will potentially force a significant change in our accepted farm practices and increase those costs. So we are here really to preserve and protect our farm, its accepted practices, and pass this legacy on to our children who are all raised here. And the legislature, when they enacted the EFU, and God bless them, their intent was to prevent these kinds of conflicts that we're going through here right now between, a non-conforming and an accepted EFU practice. So that being said, I want to emphasize this is about preserving our farm practice, not a fight against the Huffmans. In fact, they were very civil to us, and we want to be good neighbors. So, so anyway, I just want to put that out there on the table.
Okay.
So this is how we'd like to proceed today, if it's okay with you. I would like to present my statement about our farm operations and how the impact is there. My wife, Vicky, will outline our arguments and relevant evidence to preserve the record, and then she'll wrap it up at the end. So if I may, I'd like to allow my statement. Before I start there, I want to make it clear that Luba, you can't go back and get that letter from Caleb?
From Caleb?
Yeah, Caleb. I need that letter from Caleb. Oh, yeah. Was very clear, and I'm going to read this to you verbatim. And it's exactly what they said. We agree with the Guays that the findings are inadequate. The findings fail to adequately identify the farm uses and practices on surrounding lands, including the Guays' property. They fail to address the Guays' concerns regarding potential wastewater from the proposed use impacting their hazelnut farming operation. On remand, the county must identify the surrounding lands, the farms on those lands, the accepted farm practices on each farm, and the impacts of the proposed non-farm use on each farm practice. And this, according to, and I agree with counsel, Mr. Connors, that the seminal case here is the stop the dump case. That really says it all. And they are very concerned about how a non-conforming use will impact farm operations and cost. But anyway, even if the county ultimately concludes that the use will not result in any significant impacts, substantial evidence and adequate findings must support that conclusion. So anyway, I know council wants to make this a very, or applicant, a very narrow issue. It's anything but narrow. When you're in the farming community, and it's very, very tough business, and it has a lot of moving parts. So at this point, I'm gonna get right to my statement and hopefully give you a better understanding how this non-conforming use will and has impacted our farming procedures. And I want to make it very clear that the courts, and we have a bunch of cases that you can look at and reference, and we'll give you a little synopsis of each one. Look at just not what we're doing now, but what we may do in the future. And as long as we have a specific plan, and that's in Durkin v. Clackamas. But it's not just what they're doing right now that may impact us. It's what and how it may impact us if they continue that operation in the future. So let me begin. Mr. Turner, I'd like to share with you some of our farming practices to show you how the kennel operation will significantly force a change in our practices and increase our costs, both immediate and potential. These are real, not speculative. We purchased the farm in 2002. We've been raising livestock and other crops, including 34 acres of hazelnuts that are contracted out to Jeff Rumsey. They are then sold to Willamette Hazelnut. He does the majority of the orchard operation, but I irrigate, take out dead trees, and mow the orchard, among many other things. First, I'd like to address the non-conforming proposed dog kennel facility and how it has and will potentially negatively impact our farm practices and increase our cost. Last summer, we were invited over by the Huffmans to get a firsthand look at their operation. In their own words, they said they use the boarding for dogs that are being trained for different reasons. For example, they can board dogs overnight or until owners come and pick them up. We saw the interior and exterior of the boarding, outdoor training area, and indoor training area. They then showed us where they dump their clean mop water right on the ground by their picnic table, a short distance from our property. Clearly, the training and boarding are interconnected and should be considered one entire operation, as they themselves do, and council referred to. I expressed our concerns: the close proximity of the buildings to the orchard, lack of adequate fencing, exposure of the outdoor kennel to the elements, prevailing winds and precipitation from the southwest, standing water, high water table, no catch system to divert contaminated waste, mats and gravel on outer portion of kennels that allow leakage into the surface water. They seem to understand and be sympathetic to our concerns. We came to an agreement that would address our concerns, but unfortunately, it wasn't finalized. Nonetheless, the dog training building is connected to the dog kennel building. They are one intact building. One portion is about 42 inches away from the fence that has been there for over 50 years and defines the property line, and the other about 12 feet or so away. But both buildings do not conform to present code. I will also add the close proximity to the hazelnut orchard and our property creates many problems, which I will now address. On numerous occasions, we live here 24/7. I have seen dogs training on their property, dogs in the kennel, and heard barking coming from the kennels, and seen and observed dogs defecating. Some, but not all of the excrement will be picked up, granted. Dogs come and go daily. Smells and odors emanate from the facility and outdated building, not to current code. One of our biggest concerns, but not our only concern, is contamination of waste moving from their property to ours and contaminating not only the soils, but the surface and groundwater in hazelnuts. How might this negatively impact our farming procedure? The potential for toxic pathogens, bacteria, and viruses that are common to dog waste to contaminate our crop is a major concern and can remain in the environment for up to a year, according to the EPA. And we have evidence to support all this. Also, dog feces is not considered safe for human crops and not manure per the FDA. We just recently found out that Huffmans have operated the facility for the last 5 to 7 years in violation of code when a disgruntled employee, according to them, turned them in. And that's when we took action. Needless to say, this has cost us a great amount of time, money, and diverted us from our farm practices, believe me. Here's the short version of our hazelnut operation. The nuts fall when they are ready. They lie on the ground for several months or more, depending on weather conditions, and sometimes sit in standing water for a long amount of time. They are then harvested, cleaned, dried together with other farm nuts in huge dryers. In other words, they're commingled and sold for human consumption. I first reached out to Willamette Hazelnut CEO Michael Severade, who has been out to the farm numerous times, and I appraised him of the situation. He wrote a letter, which we have in evidence, expressing his concerns of the close proximity of the kennel facility and real possibility of contaminated surface water running off from Huffman's kennel to our property. He believes there's a real risk of contamination and very possibly would not purchase our nuts. See his letter. He stated that the hazelnut market is now more domestic, meaning higher food testing and more stringent safety requirements. Food safety is crucial. In 2011, after the E. coli hazelnut ordeal, I was forced to sign a document giving the USDA the right to come onto our property if they suspect even the slightest possibility of crop contamination. They have the authority to shut down our operation altogether. The FDA and the USDA take food safety seriously, as they should. In addition, he also expressed his concern that dog waste contains high levels of nitrates that can kill the trees and contaminate the soil and the crop. He noted some of the dying trees in that area right next to the kennel, which you can see in the photographs we will present and show you, and noted that nitrates from the kennel operation could very likely be killing your trees. A reasonable person would put 2 and 2 together and see the likelihood of current contamination. If Willamette Hazelnut does not buy our nuts, we have no one to sell them to, and our nuts are unmarketable. This would significantly change our farm practice and significantly increase our costs and kill our operation. Again, this is not speculative. In the Stop the Dump case, the court noted that the odors and visual impact of the dump on sales of adjacent farmers' crops was a real concern, and the same reasoning applies here. We looked into testing the nuts and soil for contamination, but it is costly, difficult to find qualified specialists, time-consuming, and the delays the harvesting process. This is impractical and economically unfeasible, and that burden should not be on us. Next, I reached out to our orchard operator, Jeff Rumsey, a qualified expert in the hazelnut industry who knows the property well. He assessed the situation and expressed concerns about the close proximity of the dog kennel facility and an immediate and potential risk of soil and crop contamination and liability associated with it. In his opinion, and you can read his letter, he said it is really not worth the risk and he may terminate our contract. I then spoke with 2 other local orchard contractors who expressed the same concerns and even mentioned the risk of dogs coming onto our property and doing their business right on the nuts themselves. In their opinion, too much risk, which very possibly leaves us with no one to manage our hazelnut orchard, no one to harvest, wash, or dry our nuts, and no one to buy our nuts. A reasonable person could conclude that the commercial dog kennel has and will significantly change our accepted farming practices and increase those costs as well, not to mention stop them altogether. Excuse me, I need to get a drink of water. I apologize.
Go ahead.
I'm not a litigator, I'm a farmer. So, excuse me, I'll begin again, if I may.
Go ahead.
Huffman's Kennel Facility has and will significantly impact our raising of livestock. This was also raised before, but anyway, when livestock are grazing in the back pasture and I hear barking, I check where the barking is coming from, which is usually from Huffman's Kennel Facility, then check the livestock. I find them in the southeast corner as far away as they can from these dogs. They are stressed, pushing fences, and not grazing because they are agitated and scared from the sights, sounds, and close proximity to the dogs. We have lost a few lambs that were prematurely born, perhaps due to the stress on the mothers caused by the dogs. Stress and anxiety reduce animal weight, stresses the livestock, destroys pasture grass, causes them to escape, jump, or break fencing, and disrupts grazing patterns, increasing our farming costs. We have 2 specific plans for the future of this farm. 1, replant the hazelnuts once the lifetime of these trees are complete. Or we can extend the pasture up the west side of the property and expand our livestock pattern, which borders the Huffman's property and others. But wait, there's a problem. A proposed dog kennel operation right on our property line do not mix with dogs. In other words, dogs and livestock do not mix. Some of the dogs listed on Huffman's Canine website are police dogs and behavioral dogs. And most, if not all, the dogs don't like being in confined areas, especially in unfamiliar surroundings and next to foreign dogs. And when on a leash, if that dog bolts for the livestock, it has a direct, short, and unobstructed path from Huffman's property to our livestock. And they mentioned fences. Well, we're going to show the fence, and you can make your own determination. Vicki might have it right here to give you a shot real quickly. That The other one.
We don't have a camera.
No. Oh, we don't have a camera? Oh, sorry. Oh, sorry. You can see it for yourself. It's be part of the evidence. A large dog can take down a 500-pound steer in minutes. Current market price for live weight for a 500-pound steer is about $4.50 a pound. That amounts to $22.50, a significant cost in addition to the disposal and replacement. ORS 609-125 through 609 reinforces the threat dogs pose to livestock and gives the property owner the right to kill that dog if it's on its property harassing livestock. While the 6-foot no-climb fence might prevent one of their dogs from entering our property, it would be costly and still not eliminate the presence and threat of the dog facility to livestock, nor reduce stress and anxiety in the herd that would be in close proximity. Livestock will not graze in areas where they sense the scent, sounds, and sight of a predator and become stressed and agitated. Even when dogs are on a leash, livestock will see the dogs and bolt or huddle as far away as possible if there's no place to escape. A number of years ago, one of our steers jumped a 5-foot fence because it was being harassed by a neighbor's dog. Also, mothers won't milk, can abort, and livestock won't eat if they are stressed or agitated. Even the nicest dog is no longer the nicest dog when they see or smell livestock. Their instincts take over. They will track the livestock down, and given the chance, they will kill it. Dogs have entered our property and harassed livestock. The animals get frenzied, the herds bolt, and they slam into fences, breaking necks, getting injured, or die from stress. This costs the farmer loss of production, time, and money. And the harassing dog can be on the adjacent property for this to happen. The close proximity of the kennel facility prohibits me from safely using any of this area to raise livestock, which forces a significant change and reduces my income due to less available pasture. I'm sure this is not what the legislator wanted when they enacted the legislation to protect farms and farmers. Any reasonable person would conclude that a commercial dog boarding operation right on the property line next to livestock can and will negatively impact the raising of livestock, increase costs, and reduce farm acreage production. And I just synthesized this. My wife's now going to go through our arguments and the evidence that we'll submit into the record, and then she'll wrap it all up. So do you have any questions on that, Mr. Turner?
Yeah, just a couple of things. Are the dogs from this kennel different from existing dogs on neighboring properties, and also the existing dogs that are part of the training facility, which is a permitted use?
Yeah, well, as that's a good question, and I'll try to answer it the best I can. When you have confined dogs in an area, 6 in that, another, or 8 and another 8, you can't put, and they're literally feet away from the border. Livestock won't be in that area, and so they're concentrated. When you have the houses and where a family dog is, they don't visit. They're not on the border. Okay, the owners take care of them, and yes, once in a while a dog will come over, and I got to chase it off. But this is totally different. These are dogs that come and go. The cattle and the sheep, once they get used to a dog bark and they know that it's safe and it's not coming over there, will bed down. They'll relax. But man, when you've got different dogs coming in all the time in these confined and quarters and close proximity, and these dogs, remember, they come out of the kennels. They're used in the training facility. They're put on leash to walk them, so they're not just staying in the kennel all the time, and they're visible to the animals, to the livestock.
Mm-hmm.
And so that poses a real problem. That hamstrings our ability to use that area. And that's exactly what the legislature didn't want when they enacted it. I should be able to use my farm the way I want to use it, as long as it's an accepted practice, and livestock, as far as I know, is an accepted practice. So that's the difference. And, I don't know how many people have dogs, but, it's not like this, a concentrated area that has a significant impact on that livestock. And I've witnessed it. I can take you out there and show you if I want to. I bring one of my cattle back there and put it back there, and they see that, boom, they're going to bolt. And if you've never seen a herd of cattle or sheep or whatever it's going to be bolt, you don't stop them. You don't stop them. They'll break the fence. They'll go. It's just it's hard to explain, but it's like a stampede. And so I don't know if that answered your question. So they're right there in that presence. It's these dogs the cattle, the sheep, they smell them and they're different each time, so they never acclimate to them. Whereas if it's a family dog, far away, and they start to figure it out after a while. And the last thing we want as farmers when we're raising livestock, if they're agitated, they won't eat. They don't. It kills everything.
Mm-hmm.
I don't know what else to tell you, but I mean, I'm just giving you my perspective as a farmer.
I understand. Are you going to submit what you just reviewed in writing so I tried to keep up in my notes, but if I have it all written down, which you clearly do.
I will certainly do that, Mr. Turner. I'm sorry if I'm speaking too fast, but I didn't.
No, you're doing fine. It just makes my life easier when I'm reviewing this, if I can follow it in writing as well. Sometimes my notes aren't all that clear because of my handwriting.
All right. Did you have any other questions?
Nope.
Okay, Vicky. My wife, Vicky, and she'll introduce herself.
Okay.
Hello.
Good afternoon.
I am going to go through our arguments, not in detail. I am going to bring this up to Melissa to have it put it in the record.
Right.
So it'll kind of be a real overview. I'll mention a few of the pieces of evidence we have, but it's not going to be very long and verbally. It'll be in writing though. The first argument, and this isn't in any order, is the lack of safe and proper wastewater management system anywhere on the applicant's property. And I know they have a waste management system, but that's where we've distinguished between the two of them. The outdoor kennels are actually, I mean, there is a new fence there, but it's not waterproof fence. It's not the inside of a building. It's a fence, a cedar fence, but there's still chain link fence around it. And when we were there last summer, it was gravel and some rubber mats and dirt. It's not a pavement there. So I guess whatever's going on the mats and gravel is going into the ground. There isn't a catchment system around it. The indoor kennel does have cement, but it's not watertight. So if the mop water's dribbling over, it's also going out onto the dirt. A catchment system would take care of that. And that's what we were talking about with them last summer. They said they mop and not hose, so that's good. You've already heard about the mop water. The only thing that was referenced in the application or maybe in your final order from last time was the mop water is dumped into a sink, but then where does the sink go? That whole thing was, a big question mark. If it's going into a sink, then that's not going in a sewer, it's going in a septic. And so then there's a whole nother commercial dog water, wastewater going into a residential septic. And so there's a whole nother question mark again. And we have evidence for you to look through to see if this, looks like that's the way things should go. According to Clackamas County, septic residential only wouldn't include commercial kennel water.
When you mentioned catchment system, I have a concept, but I want to make sure that that's consistent with what you're referring to. How would you describe a catchment system?
Yeah, we have actually, that is going to be part of this evidence for argument one. We drew up one, and then Huffman's had their engineer draw up one. So just some, like a gutter or a trough around that would catch.
Around the floor.
Yeah.
Okay.
Yeah.
Great. That's kind of what I was picturing. I just wanted to make sure we're on the same page.
Yeah.
Thank you.
So anyway, because the whole thing has to do with the proximity. So some of the evidence that we're going to have for this first argument is the close proximity pictures. We have dog feces and how that's toxic. We have other Ohio State kennel regulations. We have the fact sheet kennel, the ODA that they met with, Ben Cron. We have some of that. And then what too much nitrates do to plants and to trees, and the pictures of the dead trees. It's interesting because we didn't talk about the dog training facility through any of these, like not in our letter, not in LUBA, because it's an accepted use.
Mhm.
And so, but yeah, if we're going to bring in dog training with dog kennel as one business, then surely the fact that dogs have been on that property for 5 years and maybe been kenneled also for 5 years. I don't know when they started that, but there is, I think my husband said this on the overhead pictures that the applicants put in for their new evidence, like 44C and 44L, I think are the two places. Anyway, it shows dead trees on those pictures right by the kennels. It shows where the trees have, it's not full anymore in that section. And I have a picture of that too to put in there. So yeah, there have been, it already has had harm. Okay, so that's all for argument one. That was the biggest one. The other ones are not as detailed. Argument two is the soils in this area are not suitable for proper waste management. The Department of State Lands, I have two different forms that I think were put both in evidence. The soils are described as hydric, and that indicates wetlands. I have a Clackamas County soils map book, and it says that the soil, so you have to look on the map, and then it tells you what kind of soils are on the map, and that this area has severe ponding and standing water. And I also have pictures of our hazelnut orchard with the standing water. And then the high groundwater, surface water, we have a stock watering pond in the back. We have a shallow well irrigation that we share with our neighbors. And like, I know they said that they put in a US geological map that shows the way water drains. So I got on there too and looked, and it's interesting that Gribble Creek is much closer to wherever their map was saying it drains into. And on that property where those buildings are now, the dog kennel business, that's been probably built up according to Department of State Lands. So they put on the barns. So everything to the west of those barns where their stormwater, over by their house, over by their garden, that goes to the road, and that's probably.
Can I chime in, Mr. Turner?
Okay.
Okay. Let me help you. So their kennel operation is right on our property.
Yeah.
There's a road, Pelican Court, that it's in front of their house. And so what their engineer, who's not a hydrologist, and believe me, when we bought the property, I had a hydrologist out here, and he gave me everything and more about the water in this area. It's a very high water table. We have a shallow well that is our irrigation well. It actually pumps 100 gallons a minute. It's 18 feet, if you can believe that. And right now, the surface water, as you can see, is 8 or 10 inches away from the top of the well. So I can go dig a hole anywhere on my property, and I guarantee you I'll find water in maybe a foot or less. So anyway, that being said, what happens is the water builds up by Huffman's property and along Pelican Court on the east side. Their engineer's report, and as I said, he's not a hydrologist, but I think the report he has on that part is correct. Most likely, then they put a drainage ditch on the far side, the west side of Pelican, to try to get it down, some of the water down towards Bear Creek. But overwhelmingly, all the water from the east side of Pelican Court works its way down into our stock watering pond and into our shallow well. And then we have a large irrigation tile that runs down the middle of our property that takes water from the south and directs it across into Gribble, or into the ditch, which goes into Gribble, which then feeds into the Pudding and I mean, the Willamette and then other rivers. So that's the gravitational pull. So our concern here is, and we have a map of this, is that pull, that gravitational pull, takes all that waste away from their property, and any bacteria, feces, viruses, they all live for a long time in that stuff, and chemicals that they use is going to move its way onto our property. And you talked about a catchment system. What we talked to many kennels who do this, and all of them, have cement pads. They've got enclosed, what they call enclosed systems. You have encatchment systems that capture anything and everything. It's closed, and it goes to a tank, and then it's disposed off-site in an area that's designed for that. That's safe, because that stuff, as I said, is just toxic, and it is what it is. So when you dump that stuff and you're putting it into our high groundwater, it's just not appropriate. It just doesn't work. So I was just going to try to help you with that and give you a little bit more specificity about the irrigation. Is that part of it?
Okay.
Yeah. Okay, that was argument 2, and we'll have evidence to everything he just soil book papers and USGS maps. Argument 3 was talking about the irrigation well and the surface water and the stock watering pond. So he already went through that too, and I have evidence on that too, on how contamination would impact all of that. Argument 4. What?
Well, I just want to, we were looking at the impact of other farms, and this didn't come up. We have a shared well with the neighbors to the east of us. They spray overhead irrigation and have in the past, and berries that are for human consumption. That's marionberries and strawberries. They're now into hay, but that's also overhead spraying, and any bacteria in that water that gets on that property can and will infect livestock. So I just wanted to bring that. So it's just not on our property. It's on the adjacent property to the east. So go ahead.
Okay.
Oh, and by the way, we do, I'm sorry, we irrigate out of that shallow well when it's real dry in the summertime. So we'd be spreading more of that contamination throughout our orchard.
Argument 4, our EFU options would be limited because of the kennel proximity. Kevin talked about that already in his letter that he read, and he referred to the letter from our orchard operator, Jeff, and also the Hazelnut Company letter. So those would be our evidence for that. Argument 5 is food safety for the hazelnut crop. The nuts stay on the ground, as he said, depending on the season and how, if he can get in there and harvest them before they sit there too long on the ground, and that the USDA has access to our farm for checks. We also put in for evidence the Oregon hazelnut industry in 2011, when there was an E. coli breakout, and it was Oregon hazelnuts. Argument 6 is kind of more like questions, I guess. Just how will the county monitor all these things? If the county's going to allow this, how are they going to make sure that will they be doing on-site inspections? How will they ensure the food safety? The whole septic thing, where's the wastewater actually going? And maybe that'll be addressed with the CAFO permit, but that sounded from Mr. Connors, I was kind of, and then also reading maybe in his letter that he put in on April 17th, that CAFO will only offer a permit once some other thing has been satisfied, and that can only be satisfied if this happens. And so it's kind of sounded like a domino effect. So maybe that'll work. Hopefully that'll work.
I can answer that one easily.
Okay.
If I were to approve this, I would impose a condition of approval that they get approval of the CAFO permit. And they can't operate until they comply with the conditions, that condition of approval. They can't legally operate the kennel facility without that.
Okay,
So they have to go get that approval. If they don't get it, they can't operate legally without coming back and modifying their application and demonstrating it still complies. So there
Good.
are checks and balances in there.
Okay, that's great. Okay, argument 7 and 8 are kind of linked. It's also, again, what my husband was talking about is the livestock anxiety. And I have evidence papers that I'll put in with those for 7.
Okay.
7 was livestock and 8 was horses, since those are the 2 uses in the surrounding farms. And then the last one for the arguments was the road. And I know this was something that was brought up, but there is an impact from dust from Pelican Road, because road dust is different than field dust. Road dust has the oils and whatever things they're putting on to try and keep dust down. So road dust does kill trees. So that's all I have for our arguments. Again, really sketched, but it'll be in detail when I bring it into you and all our attachments for the evidence. Go ahead.
Yeah, Mr. Chairman, I kind of sense where you're coming from, and I just want to kind of give you and just be a straight shooter. That's how we operate. I don't know. Listen, I'm just gonna be frank and honest with you. I kind of like the Huffmans, okay? I want them to do what they want with their property as long as it doesn't interfere with their practices, okay?
I understand.
This is our livelihood.
And that's probably their livelihood.
Yeah, but this is everything we got. If we lose this, we don't have anything, okay?
I understand. And that's what I'm going to have. That's why these regulations are in place. And that's why I have to, that's why we're here.
Yeah.
And I appreciate that. And I appreciate you listening to us and taking this seriously, because it's serious to us anyway.
Sure.
And
Absolutely.
if they want to run a dog kennel operation, good. But I think you have to do it in the middle of your property, get the right permits, have the catchment systems, the cement stuff. I mean, that's how the kennels do it today. We're in the 21st century. Don't use this outdated building that was built, I don't know, pre-1975, whatever it was. Right on our border. It's literally 42 inches from the fence line. I mean, just put yourself in our shoes. Any livestock, they're not going to go in that area when you've got recycled dogs coming in, barking and foreign to them. And so I don't know, you have to put it in the middle of the property, put the catchment system, take that wastewater off site and dispose of it in a proper place. I mean, I don't know any other way to do it. I just think in the present system, it just impacts our farming too much. I mean, and unless you can show me a better way, I can't think of one that would allow me to do and practice what we've been doing. Actually, this farm goes back to 1850. It had continuous farming since then. It's the original homestead.
Okay. Thank you, Mr. Misagui. Is there anybody? I'm sorry, go ahead.
Oh, sorry. I just had, after I went through the evidences,
ahead.
I just had one more thing. Is that okay?
Yeah, go ahead.
Okay. So this is kind of how we planned on sort of closing our oral part of this. And this will, again, all be written, but Kevin started saying it, and I was like, wait, this is anyway. This is like he said, this isn't anything personal. That we met with Jensen and Elena, and they were open, they were gracious. We worked with them and came up with an agreeable plan that would keep us neighbors. And then when the plan was changed and the attorney was called in, this is when this whole expensive mess began. Huffmans want to use their property in their way, and we want to use our property in our way. And I was thinking, if we had put a pig pen 41 inches from his vegetable garden with the possibility of rains and cleaning water carrying contamination to his
That's a
garden.
farm use and probably would be allowed, but it's not
Yeah,
something.
but
No.
yeah, but I wouldn't think that would be okay. I wouldn't think that's
Okay.
neighborly.
But whether it's okay, socially okay or not, the issue is whether it complies with the law. Pig pen
Right.
would, dog kennel has a conditional use, so I have to consider those issues.
Okay, so, but okay, with the pig pen, if we put ditches and diversions and made every effort to keep our waste on our side, that would be neighborly. And
Yeah.
if we
And
hired
again,
it,
whether they're neighborly or not isn't something that's
Okay.
relevant to the issue before me.
okay,
So I appreciate everybody wants to get along, and I
Right.
totally literally appreciate that, but it's not something I'm
Okay.
going to consider. So
okay, so, okay, I'm jumping through then,
Where's your original?
this is it. So if he wants to use his property this way, great, and we can use
Yeah.
our property, we can be. Bottom line is that a non-farm use can't impact farm use. They mentioned sprays, and this is an accepted farm practice, but allowing non-farm contamination to freely move to other property isn't legal. So I thought of two steps. One solution idea is the trenches and catchment like we agreed to in July, and then maybe putting, like my husband said, moving the building away so it's not literally on the property line.
Okay.
I really fault the county for not approving this non-farm use without more conditions and safety measures.
Okay, but that we're here now. That's what
Right.
we're doing.
Okay. I'm skimming through because I understand what you're saying. It's about proximity is.
Yeah, I
guess.
understand, and that's
Yeah.
been well. You've addressed
Okay.
that very well, thoroughly.
And there isn't any way to change the soils, so there needs to be a way to keep the contamination in the soils.
Yeah, I understand.
Okay. All right. I guess I will just stop, and if I want to say anything else, I'll put it in a letter.
Great, thank you, Ms. Gui and Mr. Gui. Is there anybody
Mr.
else
Kerr.
who'd like to say anything about this? If so, please click on the raise your hand button at this point. I'm just waiting to give everybody a chance to find that raise your hand button, but I'm not seeing anybody else raising their hand. Okay, seeing none. Anything further from the county? And Ms. Lord, do we have a deadline for the remand?
Yep, that's exactly what I've got for you. On February 20th, the applicants requested that we process the remand, and so that puts us today as day 63 of the 120-day review clock.
Okay. We're going to hold the record open for 3 weeks, so. And I can't do that math in my head. Give me a second.
Mr. Turner, can you hear me?
Let's see, 28 days plus, oops, 21 days plus 63. That's 120. So that gives me, yeah, that's plenty of time. 36 days after, if we hold it up for 3 weeks. Yes, Mr. Connor.
Did you hear me?
Yeah, but you were soft for
just a second. Now,
Now
can you
you're
hear me
good.
better?
yeah,
Okay,
yeah,
good.
now we're here fine.
Sorry, it must have been when my raise hand feature was up. It messed with my audio. I apologize if I was confused when you were asking if anybody had any other testimony. I thought you were talking about public. I did
I
anticipate.
was talking about there's 2 people that are attendees. Just wanted to get, but
I was anticipating
your opportunity to respond.
Yeah, okay, great, thank you. I was assuming that, so I apologize if I didn't raise my hand at that time. So I just want to
I'm
make.
sorry, I didn't notice it. I'm looking over at a different part of my screen where the public is.
Totally
ahead,
understand. So I just want to take a moment to respond to a few of the comments. We'll obviously wait to see what the Guays submit in writing, and I assume that will be part of the first week of testimony, and so we'll respond more formally in our rebuttal on the second week to that information. But I did want to just briefly touch on a few issues to address some of the points that they raised. And then, as I said, we can follow up later in our post-record submittal. First of all, the Guays talk about legislative intent and the conflict that this particular kind of use, a use related to dogs, creates. I just want to remind you that the legislature specifically chose to make dog training facilities outright permitted uses. So I think that's a clear indication that the legislature is not of the opinion that dogs are incompatible with farm uses. In fact, as an outright permitted use, and the other evidence that you have of farm dogs, dogs in the area of other owners, I don't think that I disagree with the idea that the legislature intended for dogs not to be permitted in farm areas. It is true that kennels require the significant impact test, but as we already indicated, we believe that the evidence demonstrates that there's going to be no impact, certainly no greater impact than the dog training facility. So I wanted to touch on that. Another thing I wanted to touch on is the Gways frequently refer to this as a non-conforming use, or they talk about the proximity of the building. The use itself is not a non-conforming use.
I understand.
The building with a setback is a non-conforming setback, but you approved that, and they didn't either appeal that or any arguments related that were rejected. So the proximity of the building to the property line is not an issue that is within the scope of remand. The other thing I want to address is sort of the wastewater or the waste management plan. You know, the Gways were very adamant previously that we get a permit through ODA because ODA is the experts. As we, as we indicated earlier, originally ODA said, well, you don't have to file a permit with us because you're produce a fraction of the wastewater. But my clients were adamant and they were persistent and they got them to agree to do it. And so now we have an ODA process that at least has indicated initially they agree with our plan and believe it complies with all their requirements. And then secondly, a check and balance that will come via the condition of approval requiring that we get the permit, which includes ongoing maintenance and monitoring. That's not something that the county regulations require, but it's something that my client has voluntarily agreed to do. And it would have been nice had the Gways kind of commented on that because we figured that our voluntary decision to get that permit and rely on ODA as the expert was what they originally wanted. But it sounds to me like now they're of the opinion that they don't have faith in ODA. I'm not sure. I'll let them address that in more detail. But in terms of the waste management plan, there's been these persistent sort of accusations that dogs will defecate and they'll just remain there. And that's just simply not true. We've already addressed that to the extent that any dogs defecate, it'll be immediately picked up at that point. We have multiple employees, trainers, and administrative staff that are on site that know to do that and have been doing that for the last 5+ years. With respect to what we do with the wastewater sort of product, there's a reference to it being dumped in a particular area near a picnic table. I'm not sure if that's true or not. I can consult my client later, but I will tell you this. ODA has given a recommendation that we dispose of it in a different area. And that's what we will agree to comply with as ODA's requirements, and that will change what they're talking about. So I think that will address any concern that they have related to that. The Gways talk a lot about the consequences if their hazelnut farm is contaminated and therefore completely destroyed. They talk about consequences if their livestock is unable to exist or thrive on the property because of that. But I believe what's lacking is any actual evidence to support those allegations. Again, dog training facility on the property, 5+ years, numerous dogs in the neighborhood. There should be some evidence. If what they allege is going to happen, then their farm would be shut down by now. So I don't think that, I guess the point I'm trying to make is I don't believe that allegations of what might happen and fears about what might happen, that's not evidence. Evidence is something that's factual or data-based. And here again, if what they are concerned about were true, we would see massive impacts on their farm, and we're not. We'll evaluate the information that they submit from their manager and the other hazelnut folks and respond to that. But, again, these are, I guess I'd be interested why these same people don't think that those conditions exist today. There were some
Mr.
concerns.
Connors, I see Edward Christensen has his hand raised. Is he one of your consultant or the good?
He's one of us, and I'll just go
Okay.
ahead and conclude mine. Then I was going to turn
Okay,
over
great.
and
I
let
just
him give
wanted
a
to-
comment. Yeah, I
Thank you.
appreciate that. I did see that. I should have mentioned that. I just figured
No, that's
once
okay.
I get through mine.
Like I said, my
Yeah,
public's on one side, everybody, the panelists are elsewhere, and I wasn't looking. Go ahead.
got it.
Interrupt.
And then there was also some concern about leaching into their water source. Couple things on that. First of all, in terms of the soil, the soil sampling testing is a part of the ODA CAFO permit process. So that will be addressed. They will take that into account, and that I think will address or resolve that issue. The concern about leaching into the pond, we previously submitted evidence and statements to the fact, but that pond is frequented by literally hundreds of geese and ducks from the area. So if the Guays are concerned about contamination of that pond and that water source, then they have other contamination sources that already currently exist there that I argue would be far more substantial to have waterfowl, wild waterfowl excrementing directly into that pond than urine is what we're really talking about, making its way, or any sort of residue from feces making its way all the way to their property. I would argue that the geese, duck present a far greater threat to their hazelnut farms than anything that we would introduce there. There was some comments, concerns about dogs getting onto the property and scaring or killing livestock. Again, that's never happened. There's no evidence that any dog from my client's property has ever done that. And again, they've been operating there for 5 years. And part of the reason is the operational components to this is these dogs are always under control. If they are outside a confined area, they are on a leash the whole time. The only time they're not on a leash would be when they're in an enclosed area like the kennel, or there is an interior training facility that is completely closed off. So that is intended to ensure that dogs don't get loose. And trust me, I understand neighbors' concerns about dogs getting loose on their property, but my client would have a major problem and has major concerns about losing control over somebody else's dog that they're training. They're ensuring that that's not the case, not only for the neighbors, but for their own operational purposes. And that's why there's no evidence of that having occurred since they've been operating that dog facility. One other thing that I forgot to mention, I did want to note in the previous hearing, we introduced evidence that on the wastewater issue, my client's going to use a veterinarian soap that kills bacteria and viruses. It's intended to do that. And so that's an additional component that will ensure that whatever wastewater, there is some treatment that's occurring before it's even disposed of per the ODA CAFO permit requirements that we believe will address that issue. And then with respect to the sink, the sink comment was a comment that was misunderstood or misinterpreted by the Guays and potentially other neighbors. In the original hearing before you, Mr. Huffman did make a comment about disposing of it in a sink, but that was not a sink that's set up with connected to the septic system or sewer. It's basically what we would call a garden sink. That is a sink so that you can put it in a controlled environment, and then it will have a containment tank in it, and then that tank or bucket will then be disposed of per the ODA CAFO permit. So to the extent that the reference to sink previously, or to the extent my clients decide to use a sink to just capture that wastewater, it's not one that is connected to septic. It's a garden sink that just connects to a bucket or containment tank that will hold that information, or excuse me, hold that waste. And then the only other thing I'll say is that you heard from a lot of neighbors before. I think now it's pretty much down to the Guays that are the primary concern. And so a lot of, again, I think their concern is just the presence of dogs. But if that were the case, given the length of the dog training facility that's been operating there, you would have the whole neighborhood back here again. You would have evidence of these are the specific impacts we've been living with and dealing with. And you don't have that. You have fears, which I understand, allegations, but no actual evidence. And I think most of what the Guays rely on as evidence is really just their fear of if something were to be impacted, it would lead to these consequences. But again, allegations are not evidence. And I appreciate the Guays being transparent and honest that the Huffmans have reached out to them and try to work with them. They really have. I mean, my client wants to be a good neighbor. They want to maintain a good relationship with the neighbors. And that's why we were in negotiations with the Guays. Now, they make reference to the fact that we didn't we changed the plans. But it actually was the Guays who changed the criteria that we had agreed to initially for purposes of resolving this matter. And if need be, I can provide that information. I don't want to go into that much detail, but basically their lawyer and my lawyer, and I got involved because they filed a LUBA appeal, not because of the negotiations. And once I got involved, their lawyer decided, hey, Mike, let's you and I try to see if we can work this out. And we established very clear conditions that we can't agree to stay this for a year to see how things go. We can't agree to an approval that is subject to this sort of independent, arbitrary kind of what they call an expert or mediator that would then decide whether we're complying or not. We were saying to the extent we want to agree on things, let's agree on it. Let's get it formally introduced as part of the record, and then both parties will be happy. And I think the evidence will show that it was the Guays that insisted on these delays and longer periods of time and sort of other mediator that involved that I just know from my experience is not something that would be workable. But again, the Huffmans are willing to work, mitigate within reason and listen to the Guays, but they've made a lot of those efforts are right now. But at this point, we just don't know what more we can do to satisfy their concerns. So with that, I'll leave our responses to the specific issues for later in the post hearing submittal, and I'll go ahead and turn it over to Ed, who's been patiently waiting to make his comments. So I'll let him have his time.
Before you do, I had one quick technology question. I understand you had your hand raised, you wanted to raise an objection or something. Can't you just unmute yourself and object?
I did. What happened is I unmuted myself. You were talking. I didn't want to interrupt you. I then raised my hand, and when I tried talking, I don't think you could hear me. And for whatever reason, I think when my raised hand was still activated, it wasn't, my audio wasn't coming through.
Okay. Well, thanks. I just want, that is an option in the future, and if you can't get through.
Yep.
we're working through this technology as we go.
I know. Fun time since
Solved
COVID.
a lot, but there's still a few things to wrap up. Mr. Misquay, I see your hand raised, but I'm not going to take any further testimony from you at this point. You can submit it in writing. Okay, thank you. Mr. Christensen.
Mr. Turner, I just have a few things to say. I'm the one who has spent more time on the Huffman property than anybody else. We surveyed we physically surveyed the entire property, and it drains to Pelican Court. And from Pelican Court, it drains down the existing ditch on Pelican Court to a easement, a storm drainage easement.
When you say down, south or north?
South.
Okay.
South, and then it crosses Pelican Court, approximately 600 feet to the south, in a drainage easement that is on the Canby Needy plat. From there, it goes into a drainage way that heads down to Bear Creek, Rock Creek, and then the Pudding River. The Guays disparaged me as I don't know why. that I'm not a certified civil engineer or something, that I'm not a hydrologist. A hydrologist doesn't do what I do. I've analyzed 12,000 acre drainage sheds through 3,000 acre developments. I know how to analyze drainage. The entire property of Huffman Canine drains to the Pudding River. It is physically separated from the Guay's property. I stood there with Elena Huffman at their fence, looking down at their property, looking down at their property. There's a foot or so elevation difference between where the kennel is and where the Guay's property is. And what was disturbing is that they blame the death of their hazelnut trees on what I saw was a large ponding area, which hazelnuts do not like. They are not a wetland species. They are drought tolerant. And I also wanted to say they said that the building does not meet setbacks. I know that Mike alluded to that it was approved as far as the non-conditional use. The existing training facility was built prior to setback laws. The kennel itself is 12.44 feet away from the property line. It's only required to be 10 feet from the property line. So it exceeds the setback. And that's really all I have to say. Their property drains to Pudding River, not to Gribble Creek. The Guay's property does drain to Gribble Creek, but not the Huffman's property. It doesn't even drain onto the Guay's property at all.
Gribble is Gribble, I assume?
Yes.
Okay. To me, just finishing up my note. And then, Mr. Christensen, just for the record, you are a licensed civil engineer, is that correct?
I am a licensed civil engineer and I am an expert witness per the government, the Oregon State Bar Association. Testified in court many times.
Okay. I know you said that in the prior proceeding. I just wanted to get it on the record for this one. So, thank you, Mr. Christensen.
You're welcome.
So nothing further from the applicant, I understand. Is that correct, Mr. Conrans?
Yes, that's correct.
Okay, great. Let me grab my calendar. There it is. As I said in my remand order, I guess it was, I'm going to hold the record open for 3 weeks. For 1 week until May 1st for anybody to submit additional written testimony and evidence. That includes the information the Guay's referred to today that has to be physically received by the county by 3 o'clock. Is that 4? I think I said, anyway, 4 o'clock on May 1st. I'll hold it open for a second week until May 8th for anybody to respond to whatever was submitted during the first week. So that second week is limited to responses to no new issues can be raised during the second week. Again, has to be received by 4 o'clock. And then until May 15th for the applicant alone to submit a final written argument without any new evidence. As always, the applicant can waive that or they can submit it early. Just include a note that you want to close the record upon receipt of whatever you do submit. And I will do that. I'll get my decision out hopefully within 2 weeks by May 29th, definitely before the expiration of the 120 days. And that concludes our hearing. I will send my decision to the county and the county will send part of the record. So thank you. Have a good afternoon.
Thank you, Mr. Chairman.
Thank you.
Thank you very much.